you, Judge.
Okay.
So we spoke to Mr. Pino. Ready to go on the record?
Yes.
Okay. We've spoken to Mr. Pino, and he's going to decline the lesser included offense.
Okay. There were a couple of other things that I think there were a few other things to discuss with Mr. Pino.
I told him that there were jury instructions that we had requested. He made it very clear he's deferring to his legal counsel because he doesn't have legal training, and so he is putting his confidence in our legal team.
Okay, so I'll get that confirmation, I guess.
We can do it now. He's available by phone, or we can have him go in by Zoom as you wish, Judge.
Okay. Yeah, let him come on Zoom.
Okay?
I have the Zoom open.
Okay.
We just sent them a Zoom.
I have a Zoom, but yeah, I'll send it to him.
Can you go back also, just look at,
Oh, you want to put them on our Zoom?
I send them on Zoom.
I want to make sure, again, because I don't recall a circumstance where I've had a trial where there was a death where I did not instruct on both justifiable and excusable homicide. I don't remember ever not instructing. Now, I understand that you all agree and stipulate, but I don't want this to come back around where it's fundamental error not to instruct when there's a manslaughter charge on justifiable homicide, even if it's not applicable.
I thought I heard you read something that made it sound like it can be waived.
I did read something like that, but I'm just sharing with you the slight hesitation I have, and that's something that I'm going to ask Mr. Pino as well, because should there be, I don't know, I want to make sure that's would be a fundamental issue. And I don't know if you've seen anything on that. I want to confirm it's not fundamental.
I will tell the court I am very uncomfortable with the court not giving the entire introduction to homicide instruction.
Okay.
I'm very uncomfortable with it. I do think that the defense potentially can waive that, but I think it leaves us with a possibility if something were to happen, if he was convicted, that there could be some kind of post-trial litigation on that issue. I think the safe thing to do is do what the instructions tell the court to do, which is to give in all, it's called Introduction to Homicide, not...
Okay. I'm gonna probably continue to mull that over. I don't think it's gonna necessarily cause impact anyone's closing argument, other than if I choose to give the full instruction as part of the standard. I don't want to be in a position where there's potential fundamental error. That's where my issue. That's where I was thinking about while we took a break. Even if there's a waiver, and even if I did read something, because it made it seem like it can be done, but I'm gonna have to think about that, okay?
Of course.
And over the weekend, I'll probably be sending you all an email to advise you whether it's going to remain in the instructions.
As you might guess, we'll be working all weekend, and if there's a time the court wants to do a Zoom or phone with us, we'll be available at your call, whenever you'd like to do that.
Okay. All right.
And we're getting Mr. Pino on the Zoom.
Okay, good.
He's on already.
So he's on your Zoom.
Yeah.
Okay.
Does that help?
The camera here, do you want the camera pointed at the judge or you? At the judge?
Oh, okay.
He just needs to turn on his camera.
Oh, okay, good. All right. Very good. Mr. Pino.
Hold on one second, Mr. Pino, we're going to get the
Let's get the
volume.
audio, we'll get the audio set up. Can you hear me?
One second.
Okay, I can't hear you yet. I'm working.
Hold on, Mr. Pino, we cannot hear you.
Maybe he's on mute.
Maybe no speaker on that.
You know, if Mr. Pino wants to come into my Zoom, he can come into my Zoom. And then,
Can we send Mr. Pino the Zoom address for the judge? What's that, Phil?
Put the volume up.
might just be easier to do that.
Maybe he has.
Mr. Pino, you can hear me, but we can't hear you, so I'm trying to make this easier.
Hold one more second. Make sure you're not on mute, Mr. Pino.
He's not.
No, he's not.
He's not.
I know.
Does the TV have on?
Maybe no volume.
Do we check the TV volume
Your volume.
just versus the computer?
The computer. The volume in the computer.
I will tell you honestly, the easiest way, give him my Division 62 Zoom, just have him click off of this and click into 62.
I don't have to get them.
Text you the
Blog.
Zoom link. You sent it to him?
Well, I
Thank you.
George's number, but I sent it to our group, so someone should just be able to copy it.
I got it.
Via email.
Sorry, Judge.
Okay, that's okay. We'll get it done.
Okay, I got it.
Okay.
I sent it to him.
I sent it via email.
Good.
Okay, I have it now. Okay.
I just emailed it to his business.
Hi, Mr. Pino, are you there? Oh, he keeps coming in and out. Bad
Signed out?
connection. Yeah, he's out. Keeps signing in and signing out. I lost him again. Oh, it's terrible. Okay, I don't know if the audio is disabled. Mr. Pino, can you hear me?
Hi, Your Honor.
Hi, okay, good. All right, so I see Mr. Pino, he's on my Zoom, and just gonna ask a couple of questions. Can you raise your right hand, sir? You swear from any testimony you will be the truth, whole truth, nothing but the truth?
I do, Your Honor.
Very well, thank you. You can put your hand down. So we've been going
Thank you, Your
through,
Honor.
we've been going through this afternoon the jury instructions, and we spent several hours on them. And I wanted to confirm a few things. Counsel, why don't you ask your client the questions for me?
Sure.
Okay.
Mr. Pino, can you hear me? This is Howard Srebnick.
Yes, good afternoon, Howard. I can hear you perfectly.
Good afternoon. So we've been here since 1 o'clock. We, your defense team, including Mr. Shapiro, Mr. Armelino, Ms. Klein, we've been going through the proposed jury instructions, those proposed by us, those proposed by the state, and Judge has ruled on our requested instructions, those of the state. and we've informed her that you have told us that you would abide by the advice that we have given you on the requested instructions, that you've deferred to us because you don't have any legal background, and that you were relying on our experience and advice in how to best present those instructions for the court's consideration. As well, we've informed you that there was a discussion about a lesser included offense. It would have been the misdemeanor offense you were originally charged with, which brings a maximum sentence of 60 days in jail. It is not a felony. We discussed with you that option, and that you had advised us that you would not be seeking this lesser included offense at this time, which means that it won't be presented to the jury as an option for them to deliberate about. Did you understand everything I said, Mr. Pino?
I did, Howard.
And do you continue to prefer to follow the advice that we gave you, including declining the lesser included offense instruction?
Yes, I do.
Is there anything else, Judge, you'd like me to ask Mr. Pino?
No, I think that, so the instructions, in terms of any objections you made, any special instructions, they're all adopted by Mr. Pino, and I want to be clear that this would satisfy as a necessary part of the proceedings, an essential part that Mr. Pino actually needs to be present for, even though I did accept a waiver of his presence, because this is a critical part of the proceedings. I wanted to make sure that Mr. Pino understood why we have reached out to him today, so that down the road we have a clear record that Mr. Pino is considered to have participated in this critical part of the proceedings.
Mr. Pino, did you hear the judge?
I heard everything very clearly.
And you recall that yesterday we spoke about the option of you either attending or not attending today's conference, that I explained to you these were legal matters, that the jury would not be here, and we discussed and you preferred to allow the lawyers to appear on your behalf so that you need not attend the proceedings even though you had the option to attend. Is that right?
That is correct.
Okay, yeah, and when we talk about this again, it just, I don't know what the future will hold. So there could not be a claim later on that, that something so important and fundamental that you were not present for, that there was, you couldn't object to it later on, basically, if there was any issues that came up.
I understand, Your Honor.
Okay, all right. Okay, I think I've covered everything. State, do you have anything that that you feel I needed to ask Mr. Pino?
I just want to verify, are there any lesser includeds at all that the defense is seeking in this case?
Okay, so there are no lesser included instructions that the defense is seeking.
One moment,
All right. Just stay with us if you would, Mr. Pino. Thank you.
Of course, anything you need, Your Honor.
Okay. while I have Mr. Pino here, I'm just going to finish up with our charge conference. If Mr. Pino would please stay on our Zoom. And I think I had left off with the one question on whether 3.12D, the legally interlocking counts instruction, would be given. The state had objected, I believe, to my giving that instruction. And that goes back to the argument that was made that vessel homicide is a necessarily lesser included offense of the manslaughter, and therefore, if the jury came back with not guilty on vessel homicide, that they necessarily could not come back on a manslaughter. And Ms. Adams, if you had anything further on that, I don't know if you found any other cases or anything else you wanted to address. I'm going to go ahead and.
I don't think it is a correct statement of the law that the jury cannot find the defendant not guilty of vehicular homicide, but guilty of manslaughter. They are not mutually exclusive crimes. The vehicular homicide is not a lesser included offense of manslaughter by intentional act. Moreover, the state has opted to charge them as two separate counts. So the jury should make a separate finding as to each crime, and even if, under the Perez case, they made a finding or they decided to acquit the defendant of the charge of vessel homicide, they still could lawfully find him
I
guilty.
cannot hear you, Your Honor.
I'm sorry. You want to move that microphone up?
Oh.
I'm sorry. No, you could just take the one on your desk and turn it on if it's plugged in. There we go. Okay, thank you.
They are not mutually exclusive crimes.
Because if I understood, again, on the manslaughter, there are two theories of prosecution, which is lawful, which would be the intentional act which resulted in a death, or the culpable negligence. And that, if I understood, that was the state's position as to why they're not, first of all, they're not legally interlocking, and second, why the other requested instruction that a not guilty on the count 2 necessarily requires the jury to come back not guilty as to count 1. It would also impact how the verdict form would be prepared and read, because it would be, they would have to be instructed on, they would be instructed on count 2 first, on vessel homicide, and then there would have to be some statement in the verdict form, which is used in capital cases, where, you know, you stop here if you don't find the state has proven beyond reasonable doubt the vessel homicide.
And that's so distinct from what we're doing here. That's, you know, for sentencing purposes.
Understand.
So, I mean, to the extent that the state made I made a choice in how I charged this, and I want the jury to make a separate finding as to each crime. And even if they were to say he's not guilty of the vessel homicide, the jury still has the option of finding him guilty of manslaughter. And there is nothing to say that that's illogical or not a lawful verdict that the jurors can have. Who knows? Maybe they acquit him on both. I don't know. But what I do know is that these charges were separately filed, and the instruction that the court gives as to your verdict as to one charge should not impact your verdict as to the other. They are
It has to be
separate
treated
crimes.
as a separate crime charge.
Correct.
Okay.
And that jury instruction reflects the law, and I think that what the defense is seeking does not reflect the law.
Okay, I understand. And I understand the defense argument in this regard and the request for not only the special instruction following the vessel homicide instruction, but also the instruction for 3.12D, legally interlocking counts.
Thank you, Judge. I think this also feeds into the verdict form.
And into the verdict form instruction
Right.
as well.
And so what I'm hoping the court can explain, if not to us, to the jury, then what is the difference between the vessel homicide and the manslaughter charge if the state is proceeding under two theories of manslaughter, intentional being the A, culpable negligence being the B.
But it's an or. It's an or.
Right, it's or, but this is what I'm struggling with, is that intentional is a higher level of mens rea than culpable negligence. So,
There are alternative ways in which, by law, the state can prove the manslaughter.
it's almost, I think it's culpable negligence is a lesser included of intentional. Logically. And so, and we know that McCreary has already said that vessel or vehicular homicide is a lesser included of manslaughter. That was the whole point of McCreary. So I'm still struggling to understand how the mere choice by a prosecutor to allege both theories under manslaughter allows them to then avoid what the Supreme Court has said.
I think it depends on, in terms of the evaluation of what intentional act means and how the jury is permitted to evaluate that. The intent to, again, the examples that were given, if the jury finds that the intent to operate at the speed that the vessel was operated at, the intent to go through a point in the channel on one side of the channel versus another. The act of a change of course at some point. Those are the acts I think that the phrase intentional act are modifying.
That's their theory, but it could either be...
That's the state's
That's fine.
theory, of course.
So they've defined, however, they want to define the acts, whatever that group of acts are.
Mm-hmm.
Then the question, was it done intentionally or culpably negligently? It's still the same acts. They can't, I don't think one count can charge different acts within it.
Okay.
They have to...
I hear your argument. I understand it. I'm not agreeing with it. I'm going to instruct the jury as requested by the standard instructions. I'm not going to give a legally interlocking count instruction, and I'm also not going to give a special instruction advising the jury that a not guilty, if they should find not guilty on the vessel homicide, that necessarily requires them to find not guilty on the manslaughter.
I understand your ruling over objection. What I think the court has done at the state's invitation is said that vessel homicide and vehicular homicide are not lesser included offenses of the manslaughter by intentional act. That would be the logical conclusion,
Okay.
which I believe is inconsistent with McCreary, having said that that's exactly what the legislature intended by passing the vessel homicide statute.
Okay.
So that's one
That's
last-
our difference of
Fair
interpretation
enough.
of McCourt. Absolutely fine to do that, of course, and we have a good record.
And so, can I then, before we call it a day, bring us back to where I began, I still would like to be able to understand how the jury is going to differentiate between the two crimes if the difference under McCreary is that manslaughter has a greater degree of mens rea. It seems to me that the instructions don't accomplish that because they both deal with this conscious indifference. And so, given the court's rulings, I'm going to request again further instructions on the manslaughter to make clear that that's some greater level of depravity, I'll use that word loosely, than the mere recklessness. Otherwise, they sound the same to the jury of the instructions given.
And that was the additional language that you refer me to under the manslaughter instruction that you had provided to me.
Yes, sir.
Now, my ruling is going to stay the same. I will review it again, as I do, over the weekend, and if there's anything that should change, I would certainly notify the parties of that. But either way, obviously it's good and interesting legal argument, and I think some of these matters could be matters of first impression anyway, and we have a good record. Okay. The only other instruction was submitting the case to the jury, and I just, will the jury have a clean laptop?
Yes, I have one reserved.
And you'll make sure that the defense looks at the laptop, make sure it's a clean laptop.
Yep.
And for any digital evidence.
Yes.
Because I don't bring them out if they ask to see digital. I want them to have everything they need in the jury room.
Yes.
And be able to view and listen to all of the evidence. So I'm just, in my mind, thinking, documents, audio and visual. I want to make sure they have everything they need. So if I'm missing anything other than a clean laptop,
I will also have a DVD drive that can be plugged into the laptop because one of the items of evidence that was introduced was a DVD.
okay, good. All right, because it was in a DVD. Okay. I can't think of anything else.
There may be one other issue that now we have to address, which is unanimity as to the theory of manslaughter. 'Cause
Okay.
now, right, the state is proceeding under two different theories.
Which is, okay, so, right, whether or not there needs to be a special verdict where the jury would have to find unanimous as to either manslaughter by an intentional act leading to the death or culpable negligence. Similar to if we have, I guess, a first-degree murder with premeditation, right?
I've never done a first-degree murder case.
Okay, premeditation or felony murder. I think I'm going to think of this as an argument along the same lines because I haven't researched the issue of whether or not with a manslaughter, with the alternate theories, whether or not a special verdict is necessitated.
At a minimum, I think at least a jury instruction that they must be unanimous as to whether it was an intentional act or culpable negligence.
I don't have any case law on that at all, and I invite anyone to find me a case that would require that. In fact, for the request, I'm going to leave it at that. Right now, I'm going to decline to do that, or to create a special verdict form to do that. But if anyone, state or defense, should find any kind of legal authority that would require a special verdict, I would love to see that. You'll see this now in the context of, enhancements. It comes in for the purpose of sentencing. In the cases that you're going to find where there are special verdicts, it has to do with if there would be enhancements for a jury to make. A jury would have to make a special finding for certain enhancements. That's where you'll find the cases that talk about special verdicts. Okay? So if you find anything, I'd love to see it. I've not seen it before, but because when we talk, even it has been a lot of discussion over the years in murder cases over felony murder versus premeditated. And while it continues to be an issue that defense counsel raised, I think the Supreme Court has maintained the position that there is no special verdict for the jury to find unanimously either a felony murder or a premeditated murder. So I'll leave you all with that, and I will see everyone at 9:30. We'll start up 30 minutes. At least we should meet 30 minutes before, and I have coverage, so we'll be good to go.
I will just, I have I think a small table that I would like to bring with me to the courtroom just because.
I can't hear you, Your Honor.
Okay, I'm sorry. I think counsel was going to bring a table to set up in the courtroom, I guess, so that the evidence could be kind of, instead of going back and forth, and I think everyone might have access to it, right? If you bring a table here,
I would share it.
you would share it.
Of course.
Very good. So it just makes it easier to set up any evidence on that table as opposed to coming back and forth to the clerk. So that's fine, and I think that would be fine with defense because we're going to share. Okay.
Judge, what schedule are you proposing in terms of where we're going to break during the course of the
Okay.
closing?
I propose you think tell me how you think you're going to break up your closing generally.
I think probably if I would need maybe about an hour or so for
I cannot hear her, Your Honor.
I think I would need about an hour or so for my initial close.
About an hour or so.
And again, I would reserve about 30 minutes perhaps for rebuttal.
I will tell you, I do not put time restrictions on, I don't do any opening, I don't do any close, I don't do that. So if you're a little bit over, a little bit under, I plan to give you a couple of hours. I think you all indicated you wouldn't need more than 2 hours, but I'm not going to put a restriction. So you're going to break it up, and what I think would happen is after the state's first close, we would take a break. You could then figure out how you want to set up the evidence, and then the jury would come back. You do your close in its entirety, and then what's going to happen is we're going to have to break for lunch at some point. That's probably when we're going to break for lunch, okay? And after you finish your close, we're going to come back, and the state, I'd like to see if we could finish the state's rebuttal close before I break for lunch, but I don't know that that's going to happen.
If the state is about an hour, I think I'll be about an hour, in which case I think we can get them all done.
If that's the case, that's fine, but I don't want to break too late for lunch because I have to have a break for lunch and then instruct the jury. And I need to get them out and instructed, I would say, no later than 2:30, 3 o'clock, and get them working. And I don't tell them this, but I'll keep them working. I'll order them dinner and not interrupt their working until they're going to turn the lights out on us, which is about 8:30 or so. Okay? And at that point, if we don't have a verdict, they come in, I instruct them, and they come back, and they go right back into the jury room the next day. They don't even see us. They're just taken right back into the jury room by Renee. And this, in fact, this courtroom is, while the jury is in the jury room, no one's permitted in the courtroom, except for Renee. And the clerk could sit here, and Vanessa could sit here, but no parties, no spectators. The room is clear. And so, once they start deliberating, we're not going to have anyone in this courtroom unless there's a question, and we'll all be in the courtroom, and or we have a verdict. Okay, so no one is in this courtroom at all. So if you're going to have, we'll talk about that, but you'll take things out with you that you need to take out with you because you're not going to have access to come back in.
So I've got a question with the essentially equal time being provided to both sides in the closing arguments. So I appreciate, as a litigator, that the court does not impose a hard cutoff, but I just want to be clear for our purposes, for our planning purposes. If, for example, Ms. Adams were to take an hour for her close, and then we took an hour, 15 minutes or so, the prosecutor's final close, rebuttal close, it seems to me there should be at least some restriction, to provide at least fairly equal time between the parties addressing the jury.
Okay.
I'm just wondering about that.
Well, let me say this. We have to be reasonable, okay? If you're able to consolidate your close in an hour, and they've taken an hour for the first close, I'm not going to deprive the state of their opportunity to come back with a rebuttal close. That's what the law allows for. And if it's 30 minutes rebuttal that they're asking for, then that's not unreasonable.
Well, I agree that as long as the rebuttal is, not more than, let's say, 50% of their opening, I'm not going to complain that they've exceeded how much time I use. But
Listen, I understand, but I play it by ear also, and I give the state a fair chance to rebut because the rules allow for it, and they get the last word because it's their burden. So I would give them a fair chance to rebut, and I've not had any issues about this that I can ever recall. I think we could all manage it fairly well. What's fair? They're going to have a chance for a rebuttal close to rebut your closing. So, and if you have any concern, then you should raise an objection, and I will handle it accordingly. I will either say sustain the objection, or I will overrule and let whoever's doing the rebuttal close, know that you have, start to wrap it up or whatever my comments might be, because I'm obviously going to listen very carefully that it's truly a rebuttal close, right? So I think we're good on that. All right.
Last question, just
Yes, sir.
logistically. Once the jury begins its deliberations, is the court going to require that the parties remain here in the courthouse, or will we have a...
Just you're going to give me all your information, and you're going to be on call. And for questions, you have to be accessible. I've done it at times where we've done it via Zoom. I don't. The questions, I don't bring the jury in generally to answer questions. They'll come in a note. I'll get the parties together. We'll decide what I'm going to respond and how I'm going to respond in the note in a handwritten response, and that goes back to the jury. Kind of have to play it by ear depending on what their question or concern might be, if there is one. You're free to do what you need to do. Just you want to be within a reasonable time to be able to access either the courthouse or Zoom to answer questions.
Thank you, Judge.
Okay. You all have a good couple of days, and I'm sure we'll be in communication. See you 9:30.
Thank you.
Thank you.
Thank you, Your Honor. I truly hope you have a nice weekend.
Okay, you too. Thank you.